When you speak of freedom of association and collective bargaining, the ability of workers to, not just workers and employers as well, to act in concert, to negotiate for their interests, working hours and holiday. This sort of forms a basis for the enjoyment of all of the other rights that you find. And so they are core labor standards. They are fundamental principles of international law. They are basic human rights, fundamental human rights. I found that they sort of have an approach that is undermining these rights because they base their rationale on labor flexibility. So, for example, collective bargaining taking place at the very local level rather than at the national level or sectoral level. I gave some examples of a country where the financing was on the condition that certain laws on collective bargaining should be amended, and this was the result, that these laws were amended, and then collective bargaining was given more emphasis at the enterprise level. And again, this would be in contra to the ILO conventions, which have very specific requirements when it comes to collective bargaining. Where does it take place? At what level is left to the parties? I think it's increasingly important to look at the other forces out there that affect human rights and move away from the traditional notion that human rights impacts are basically where governments violate certain rights. So we have all these actors, and the interesting thing is that the legal framework doesn't really enfold them. So we have sort of these little cracks through which they operate. And so it is increasingly important to really look at other actors than the traditional ones that we have been accustomed to, so workers, employers, and governments, because their impact, the legal implications, are just as defined.